Is this thing working?
It just started working.
Yeah, good, thanks. All right, we're gonna take up Representative Wade's measure first, and just so the committee members know, we are going to be looking and dealing with LC 442058S. So make sure you're working from that copy, and go ahead.
Thank you, Chairman.
Let's see what. There we go.
Thank you. Thank you. Okay. Thank you, Chairman and committee members. I appreciate the opportunity to present House Bill 1350 as LC 442058S. This is a bill that did pass out of the House unanimously. There's one slight change, and I want to make sure that I let the committee members know I've spoken with the chairperson, and I think several of you may have heard, but I want you to hear from me. Apparently on crossover day, sometimes things get crossed up, and a different version, LC 442056S, was passed, which was a final committee that was prior to the rule substitute that was approved, so they just had a mix up on what actually hit the floor. The only change is on line 51, and that's what you see now. The old language on line 51 said bank or trust company at the beginning of that sentence, and working with the associations with the credit unions and the banks and the departments, we determined that it would make more sense and be more consistent with law to have financial institution as the reference on that line. That is the only change as to what was passed in the House and now comes to you as a Senate amended substitute, I think would be the language. Now, as to what the bill does, it basically does two things. One, currently in law, as it relates to estates and wills, heirs are required to receive notification. What this does is it simply adds beneficiaries to that notification requirement, and it lays out the process for that. We did work with the probate courts. Their associations went through several iterations through the committee process in the House to get this right. In my community, we had an incident in which there was a pretty large estate that was handled, and unfortunately the executor made a decision not to. They sent all the funds and the assets as prescribed by the estate to the heirs, but neglected to send those things to beneficiaries. And subsequently, through kind of a luck of the community, there was an investigation, and that person and then recently their husband was arrested. But the intent is to ensure that for beneficiaries such as people like St. Jude's or your local church, your Rotary Club, a college foundation, if they're named in a will as a beneficiary, that the executor does a good conscious effort of making sure that they're notified. And the second piece of the bill, which is in section 2, was a request of the department, banking department, to just clean up a little bit of language as it relates to items B and C or really just item B, creating what was formerly B, now C, to ensure that investment management account, investment advisory accounts, investment agency accounts, custodial accounts, or any other type of security or trust account with a financial institution will still have the same beneficiary requirements under the Uniform Transfer on Death Security Registration, which is in Code Section 53-5-61. So it's really just a cleanup language that they brought to my attention and asked us to attach that to this bill. And that's what the bill does, and I'm happy to answer any questions from the committee, and I appreciate your favorable consideration.
Do I have any questions?
Just a point of clarification. So the bill that passed the House
Yes.
is not the bill you wish us to consider?
So it's a
So this would be a Senate substitute to a House bill, is
That
that
is
correct?
correct.
Right.
It would have to go back to the House for
Yes.
Very
Yes.
good. Thank you.
yes.
Anybody else? Do you have another one, Senator Burns? No. Okay. Couple of questions. One is,
Sure.
what House committee did this come out of?
So it came out of the Judiciary.
Okay. And then, have you had any discussions with anybody from the State Bar or the fiduciary section?
So yes, we did actually. So Chairman F.S. Tration worked with me as well as the folks from the department on those concerns and questions, and that's where we derived at our final language.
Okay. Great. All right. Any other questions? What is the will of the committee? All right, do I have a second? Okay. Did you get Chairman Burns? And then a second by, Well, hold on a second. Hold on just one second. All right, we have a motion do pass for LC 442058S. And I've got a second. All in favor, say aye. Aye. Any opposed? All right, looks like you're there.
Thank you so much.
With respect to this, do you have a carrier?
We do, and it's actually Senator Gooch.
Oh, interesting. Interesting choice.
Senator Gooch and I share representation over Lumpkin County, and he had an interest due to the issue back at home, so he also worked on it. Thank you.
Great. Thank you so much. Really appreciate it.
Thank you all very much.
All right, Representative Corbett. Welcome.
Thank you, Madam Chair.
Go for it.
All right. Good to be here today. Good afternoon. I bring to you today House Bill 1294, LC 393220. This was brought to me. This change was requested by the tax assessors in a county I don't live in, but anyway, we passed a bill a few years ago dealing with abandoned mobile homes, and if the home was deemed to be derelict, basically unlivable, not worth actually a liability, because it's going to cost you money to tear it down, but they had to post a notice that same day that they received the determination that it was unlivable, a derelict mobile home. We're just giving them 3 days in which to post that notice. Now, they were having an issue being able to get out on the same day if they get a determination on a Friday or late in the afternoon, or with COVID really just made this problem worse. But they just asked to have 3 days to post that notice instead of having to do it on the same day.
Okay, great. Any questions?
Three-day notice, I'm just saying, to dispose the...
Yes, one is derelict, unlivable. It's basically a liability to the landowner that's on it. It's a blighted property, so they'll be able to dispose of it. Before, it was illegal for that landowner to take, even though it's not worth anything, to haul it to a dump. That was illegal because it's got a tag and title just like an automobile does. And there was a process in code to do away with abandoned motor vehicle, but not a mobile home. And this allows a process to do that, retire the title, and the same process as abandoned vehicle.
Thank you, appreciate it.
Yes.
Madam Chair, if this is appropriate time, I'd like to make a motion to pass.
It is. Second by Senator Rahman. All right. All in favor, say aye. Aye. All opposed? All right.
And Carden Summers.
Great. Thank you very much.
Thank you.
We appreciate it.
What? Senator Carden Summers. I stand corrected. Senator. Thank you.
Thank you. Representative Smith? Yours has a little more heft to it, so it may not go as quickly
No, that's fine.
as the
I
others.
completely understand. Thank you, Madam
All
Chair
right.
and members of the committee. I bring for you today, substitute HB 1352 is LC 442036S.
Okay.
This bill deals with unclaimed property that's at the Department of Revenue, DOR. And of course, that property is actually the citizens' property. And what we're trying to do is to help the citizens receive what was probably in their family, maybe in an estate, may have been a dad or a granddad that's passed away. So we're trying to get that property back in the hands of the people where it needs to go, that own the property. This section we're looking at hadn't been updated since 1990. And on this return property, if you look at the percentages of how much property we return back to the citizens compared to the United States as a whole, we're returning about 9%. The U.S., the average is 38%. And if you use a state as an example, sometimes we don't like to go out and compare ourselves sometimes, but if you look at Florida, they return about 59% of the property. back to their citizens. So that's what we're doing here. And we're in this bill, if you look through, it allows companies, there are companies out there that actually do this. So it allows companies to register with the Department of Revenue. They pay a fee, $1,200 every 4 years. The Department of Revenue can do a background check, make sure these companies are on the up and up. And then when they go to contract or help someone, a citizen, to do this procedure, it's done in a contract form. They can charge up to 30%. Right now, the averages with the number of companies out there, the average is about 17% is what they charge. And that's kind of rated according to how big or how much trouble it is to get their items back to them. So they weigh that. But it's it also states in the bill, when we went through the Judiciary Committee in the House, we had input from by Zoom from the probate courts. They had a certain language they wanted to go in this bill. I'm not a lawyer. I should have said that in the beginning. I'm not a lawyer, but thanks for working with Josh Belafonte. He's helped me a lot on this, and I appreciate it. But they had language they wanted to go in the bill, and it had to do with making sure that the wills and all the trust documents are kept intact and not destroyed. And so those documents are maintained, and the DOR maintains also electronic copies of those wills and trust. The bill would not take effect until January 1 of 2023. When I talked with DOR in the beginning, they need some time because we're trying to make it where their databases will be searchable. People can go in and gather the information and work to get all this information, this property, back to the people. So we want to give them some time to do that. So that's basically an overview of the bill, and I'll be more than happy to try to answer any questions that the committee might have.
Great. Senator Goodman?
Excuse my ignorance on this, but I mean, can you give me an idea of what some unclaimed property might be? I mean, and how the state would have come about being in possession of it? And
well, the way I look at it is maybe even if it's a close-knit family, but some families may not be as close-knit, and they might not know that an uncle may have left something to them. It may even be something physical that you can put your hands on. It could be furniture. They actually have a facility, and Representative Corbett that was just here has been over there, and he and I talked one day. He said, I want to take you over there so you can see where they have this property stored. So I'm looking forward to taking that trip. I just hadn't had the time. But yes, it can be physical stuff, or it can be something in a will or a trust. Maybe it was some bonds, stocks, bonds that were left over, and the people just didn't know it. And now I'm not saying DOR does send out information letting people know that there's property there. And I think I've heard the stories, and you get that information, and then when you try to go through the hoops, it's a pretty little process you go through to recover that unclaimed property, all the way back to getting death certificates and that nature of business. So that's the reason when we're talking about these companies out there that do this, I think that's probably why you see that percentage so high in Florida and so low in Georgia. Now, let me be perfectly clear. Individuals can go through that process and recover that property themselves. They can hire their own attorneys that do that. This doesn't prohibit that at all. But with that rate so low at 9%, I'd love to see that stuff get back to the citizens, where it belongs.
Want to follow?
Sure.
Do you have any idea what the value is that the state's holding right now of unclaimed property?
You know what? I do not. I should have found out the answer to that, and I apologize, Senator. I do not know what that amount is, but I'll be happy to try to find that out and get with you personally and let you know. Yes, sir.
Thank you.
Senator Parent, are you for?
I am.
Okay.
Thank you, Madam Chair. Thank you, Representative. Just wanting to follow up a little bit on Senator Goodman's question. So I don't know much about this at all. In fact, I didn't really know anything about this unclaimed property situation or enterprise until the bill, was assigned to the committee. So I'm really just learning. But am I correct that, in some states it's handled by the government, like the government doesn't allow third parties or middlemen industry to come in, and the controller's office instead handles getting people their money back. Is that correct?
I would say you're probably correct. I can't name the states that don't allow it and the ones that do. I know like California, Texas, Florida, I know those three right off the top of my head allow that to happen, but there are probably states out there that may not allow it, but I don't know the names of those.
Well, I did. Speaking of California, I did go on their website, and again, like just with everything going on around here, I didn't have a lot of time to really delve into it the way I would have liked. But I noticed that was run through the controller's office, and they seem to have a whole lot on their website related to it. And I also went on. You mentioned Florida. I also went on their website, and isn't it correct that they had to come back in a couple years ago and cap the fee because the private industry, the middlemen were like taking too much money, and they were like, this is turning into a problem? I mean, I think that happened.
It could have. You could be correct. I don't know the answer to that. I know I have a chart here of all the information that states like California, and I'm sorry I don't have a copy, California, Florida, and Texas, here's the information that they gather, allowed to gather to return this property. And some of the categories they allow a lot, and Georgia allows four little categories, but that they share information about. But you could, I think every state may be different. It could be, but
Could we possibly get a copy of that chart?
yes, ma'am. I can give you this one, or I can have some made and send to you.
That would be great. I just am interested in your thoughts as to the relative benefits and demerits of having it handled more on the governmental side, so that you don't run into consumer scam situations versus like allowing the Florida model, which this I think is. Am I correct about that? This is basically the Florida model? Right. You know, I mean, either way, the people could get their property back, but my concern is, which is a good thing, but my concern is making sure that there's the appropriate consumer protections built in. You know, I found a long article on State Line about, the title is "Watch Out for Unclaimed Property Scams, State Officials Warn." And I wish I'd had more time to really delve into the scheme that's set up here to feel sure that their reporting requirements and consumer protections are built in. I kind of ran out of time.
No, and I completely understand. I think that's one reason in this part of this bill is that DOR has to do a background check on these companies that come, and these companies have to register with DOR. They pay a fee of $1,200, and they do that every 4 years so that they try to keep people from having, scamming our citizens. So that's the reason that's in the bill.
That's great. So, okay, so this is UPPO. If I can ask one more question, Ms. Chairwoman. UPPO, they are a trade industry of these
people.
These people, right?
That's what I would say they are, a trade industry, yes.
Okay, because there's also, I know, a governmental professional organization, the National Association of Unclaimed Property Administrators.
Okay.
So that would probably, do you know, that would probably encompass the broader whole, where sometimes the state's handling it, sometimes they're working with these third parties, but my understanding is, and I'm correct, that this is the group of the type you're trying to sort of allow more of here in Georgia.
Yes, ma'am.
This is the trade
industry. Corrected.
Okay, thank you.
I rely heavily on my lawyer.
I understand.
And not being a lawyer, and
I understand.
I don't want to pretend to be one, but.
I have a couple of follow-ups with respect to Senator Parent. First off, you indicated about the background check, but in terms of the entities, but with respect to that, are there any requirements? In Georgia, it's very easy just to get an LLC, up and running, in a week. And so the question is, in terms of past business, is there any requirement other than they just have to be an entity that they can run a background check on?
I'd really rather not try to answer for DOR, and if Josh knows, I'd love to have him, if it's okay with you, to answer that. But
Sure.
My opinion is when they register, and I won't even try to answer. I'll just wait and let Josh answer that. Thank you, Madam Chair.
Good afternoon, members of the committee, Madam Chair. In lines, looks like 238 to 242 of the bill is the background check issue. I will say that to the extent that there's anything that's, unclear in this, DOR can pass regulations to clarify further. But it would say that the person would have to go through a background check, criminal background check, look and also make sure that there's not a civil verdict for breach of fiduciary duty. If someone were sued in their personal capacity for that, that would also need to be disclosed and show up as well. So to answer the question, perhaps even more specifically, if there is an LLC that someone forms, the LLC is not going to be going through the criminal background check. It would have to go through to the individual. We see that, for example, at the lottery, where you have entities that register with the lottery for various things. They follow through to the individual behind the company. My presumption is that the DOR would do the same thing as they do with retail licenses for alcohol and tobacco. And if there's any question of whether they would do that, I think they would have the rulemaking authority to make that clear.
And so with respect to this, it sounds like Representative Smith, you believe DOR is not doing what they need to be doing if we have such a low return rate in terms of unclaimed property.
Right. Like I say,
I mean, that kind of seems like the issue.
I don't want to be, I'm not trying to be critical of the department.
It's
they got
okay.
a lot going on. But I think with the 9% return rate, and then you look at somebody right next to us got a 59%, and the national is 38%, that makes you go, wow, are we doing what we should be doing, getting that property back to the people? That was my bottom line.
And did DOR have any kind of, I'm assuming y'all talked to them about this, and kind of what is their take on all this?
Well, the first thing they said, they want more time. We were going to institute this, let it go into law if it passed July 1 of this year. But then they asked for more time. We compromised on a middle ground, and that's the reason we decided January 1 of 2023 to give them time to, I guess, to get their databases, computers set up to do this. And I guess you just consider this another option. Like I said earlier, the individual can do it, their personal lawyer can do it, or here's another option. If they want a company that has done this in other states that have a track record, that would allow them to choose those companies.
All right. Senator Anderson.
Thank you, Madam Chair. Let me take my mask off since I have a microphone. Thank you, Madam Chair. Representative Smith, I appreciate you giving us this information.
Yes, ma'am.
As I looked at the chart, it is very interesting that, as you said, Georgia is at a, again, lower level of communicating to people about their unclaimed property. So out of all of the categories, you see the owner's name, state, zip code, and property type. This is the only information that they have to try to contact people. But there are ways that they have to find people to when it's the opposite, when it's turned the other way around. So if they owe you something, there's very little information. But if you owe them something, there's a lot of information. That's my point.
Said it better.
And this is very disturbing. The rate of inability to contact people about their property. I had unclaimed property that I did not know about until I tried to. It was a gift card that was given to me, and I actually forgot about it, found it. But it was a very nice resort. And I called, and they said Georgia has it. I said, what? Like, Georgia has it. I was like, how did they get? So people who don't have access to this process lose. So because I called, was able to reach out to DOR, they were able to walk me through the process, get it reinstated, and the owner was like, whenever you're ready, then you can use it. But had I not reached out, I wouldn't have known. So imagine someone not knowing that they had property and this goes unchecked, unnoticed. I think it's an excuse to ask for more time. I won't amend your bill, but I will support your effort to try to help people retrieve their property. Now, what is the process now? Is my question really? What is the process now for people to be able to retrieve property that they may think that they have?
Well, you have to contact DOR. They send you the forms that you have to fill out. I know one of the items you have to get is a death certificate. If it's like, say it was my dad's passed away, say my dad, and he had unclaimed property there, I have to get his death certificate. I have to fill out the forms that they have, send that back into them, and they have to verify everything before I'm allowed to. And that's a very simple version. And
Yeah, I'm sure the process isn't simple though, but thank you.
yes, ma'am.
Thank you, Madam Chair.
Senator Merritt.
Thank you, Madam Chairman. You said I hear that the issue might be with DOR not responding. How long have you been trying to engage with them to do some corrective actions?
Just this year. You mean as far as this bill? Just this year, yes, ma'am.
Okay, and there's been some questions for them, or some grievance filed to.
I can't speak to whether there were any grievances. I just, but again, I go back to that small percentage rate of property that's sitting over there that should be our citizens, and that's what put up the red flag, I guess. That's the basis of the whole thing, is to try to increase that percentage number, and at 9%, that's pretty low.
Okay.
So.
Okay, that's my question. I might have a follow-up in a minute.
And I think kind of just to close the circle a little bit, this didn't come from like a constituent who came to you and said, I had this unclaimed property and DOR didn't get it to me. It wasn't, that's not kind of what we're talking about.
No. Josh and I talked in the very beginning. When I realized what was going on, he'd show me some numbers about this, and that's what kind of started the gears turning, and then here we are. So.
And Mr. Belafonte, what's the organization that you're repping?
Sure, and I should have said that at the beginning. Thank you. I'm Josh Belafonte with the Robbins firm. I work with Choice Plus on this legislation. And one of the things that they do, and it's one of the reasons the numbers get high in states where they and others like them operate, is that they go through the data and then notify people that they actually have unclaimed property. If you don't know whether to look for it or don't know whether to go to the website that the DOR maintains, you may not know that you have it. And where they become particularly useful is when you have complex issues where, it's a safety deposit box that Dad had but didn't tell anybody about, and there's life insurance proceeds in there, and maybe he just forgot about it kind of thing, and there's 6 different heirs involved. They get involved and try to assist with things like that. So what they've done in Florida, where the number's so high, and in some of these other places, is mine the data and then tell you have unclaimed property, you can use our services or you can do it yourself. And they only have about 7 to 8%, I think, of people actually use their services. So most people either don't do anything or they handle it themselves. But that's their business. That's what they do in Florida, Texas, Oregon, Colorado, and several other states.
Senator Rahman, did you still have a question?
Yeah, well just a little comment. You said about $1,200 fee for 4 years. That's really like $300, a year. But it's currently like 10%. I'm a little confused about, at 10%, 30%. I'm trying to figure out what the 30% looks like. They're going to take 30% of the value of the property, basically.
Well,
Okay.
30% is a cap. They
It's a
can't
cap.
charge over 30%. So, sometimes I guess you hear people charge 40, 50%. They get half of whatever they get back. But this is capped at 30, but then it's negotiated because there's a contract that they give to the citizen that they're working with, and they state on the contract what their charges will be before they ever sign the contract.
It sounds a little bit too high for me, but anyway.
No, I understand. That's
Senator Goodman.
Just a quick question. Former Senator Ellis Black had this was something that he was always interested in, and he sent me different names of family members that had unclaimed property. So I just pulled up one here. This is my wife's great grandmother, and she's got listed on the database. The problem is it doesn't tell you what it is. You know what I mean? And so I wonder sometimes if
If you knew how good it was.
yeah, you know what I'm saying? You know what I mean?
yeah.
It'd be nice if the state would tell folks what it is before they go through a whole lot of trouble and hire these people and everything else, before they start going down that road. Just a little little thought there. So anyway,
Yes, sir,
thank you,
so,
Madam Chair.
Thank you.
All right, Senator Parent.
Thank you, Madam Chair. I was going to ask you, Mr. Belafonte, the same question I asked Representative Smith, which I don't think you didn't fully know the answer to, understandably. Are you aware of, sort of in this space, how many, just the details on how different states handle it, i.e. there's the Florida model.
Right.
Then there's are there ones that don't allow any private companies? Can you explain the
Sure.
industry a little bit more?
Yeah, I'm
or
not
just
aware
the space a little bit more? I guess not the industry, but the space.
Right. I'm not aware of any states that don't allow, because I think at the end of the day, anybody could probably hire an attorney to assist them do this, and I don't know that a state could say no to that. So,
Fair point.
with that exception, I don't know. I do know that states verify, and we see Florida does have the highest rate of return of property. California is pretty close there. California, there was some question about the cap in terms of compensation. California, I think, is in the 20s. It doesn't go as high as 30, but what I understand from talking to the client and to the association is that in states where there is even a cap of 30, your average rate is, I think, Representative Smith said, is going to be about 17%. The higher numbers in terms of what they would be on a contingency basis, the higher numbers tend to be for those complex cases I talked about before. But in terms of a state survey and how many allow more and don't, I don't know. I know this is gaining attention across the country. Michigan has recently looked at legislation in this. I think Wisconsin has done the same. Colorado recently passed something. So it is something that states are now looking at more. And like our law, it has not been updated since 1990. And there's just been a lot of obvious technology changes since then that could make a lot of these things the committee suggested easier.
Anything else, Senator Parent?
No, thank you, Madam Chair.
All right, any more questions?
Madam Chair. I was paying attention, but I Googled my name. I got some property out here, girl. I gotta get
Senator Goodman.
Last question. I'm just curious. Wouldn't it be nice if the state would tell us what the property is before we decided? Because if it's grandmama's cake pan, that's one thing. But if it's $2 million worth of stocks and bonds, a person would like to know that before they hired somebody at 25%. You know what I mean?
No.
Just a
I don't disagree. It's in the contract.
If I may, Senator, in the contractual form that's in the legislation, the company would have to notify you what the estimated value of the property is. That's also one of the data points that would be required if the bill should pass.
Of DOR.
Would they have to, Madam Chair? It's okay.
Yes.
Would they have to? Would they let this citizen know what the value was before they signed the contract?
Yes.
Okay.
It would be
Thank you.
part of the contract,
The
so you would
notice.
see it before you signed it,
Thank
what the estimated value is.
Thank you.
Chairman Burns.
Just a point of clarification. The Department of Revenue, I think you alluded to the fact that they may be updating their information technology to allow potential individuals to access that data. Is that accurate?
What they asked for, once we started working on the bill and talking to them, they wanted to have more time. That's the reason we didn't let the bill, if passed, go into effect this July 1. We're holding it to January 1 of 2023 to give them more time to make sure everything's updated so they can accommodate people and individuals and companies.
Just a follow-on, Madam Chair. If the Department of Revenue provides online access to a potential property owner, that would help facilitate their desire to try to work toward recovery. And again, I agree with your position that they can do it themselves. They can hire an attorney. They can contract with a third party. And I have I have no concerns about any of those options as long as any contractual agreements between the attorney or a third party would be known up front, and they'd have an estimate of what the value of the property was.
Right. And disclose their fee also. Right?
Absolutely.
Yeah.
Disclose the fee. And that one more follow-up. I apologize. There's no upfront fee for a third party to do a review to determine whether or not there's value there.
Not that I know of, and Josh may know more about that, but
That's a question. Is there an upfront fee?
I don't know of an upfront fee unless you know of one, Josh, by a third party.
They are allowed to get to search the data, and I believe that there is, following like the Open Records Act type thing, there
Yes.
may be a fee along that. I think that's in there.
So the only fee would then be the potential cost of an open records request. Is that fair?
It doesn't expressly reference the Open Records Act, but that's the model that I know was at least contemplated.
Thank you, Madam Chair.
In terms of the notice that goes out, Mr. Belafonte, is there an indication, so if I get the notice, it says, there's this unclaimed property, the amount, all of that, and I can secure the services of the entity sending me the notice. Does it also require that it indicate that you don't have to use that company, that you can just do it yourself, go through DOR, hire a private attorney, or it's silent on that issue?
Let me clarify if I misspoke. The notice itself is not part of the legislation in terms of the notice you'll be provided, except that companies that access the data can only use it to solicit the property owner. That's the only piece that speaks to notice, but it's in the contract that someone would sign with the third party that would go through and list the estimated value of the property, the contracted amount that they would be compensated, et cetera. So the notice itself is not regulated.
Okay.
But we see in other states that have this, again, about, I think they said between 7 and 12% use the service. The majority don't, because they either find a way to do it themselves or they decide it's like the cake pan and it's just not worth any time.
Okay, so there's no requirements in this legislation with respect to the notice that the consumer, the Georgian, gets with respect to the unclaimed property.
That's correct.
Okay, it's only once you get to the contract stage where they're about to execute a contract with this third-party unclaimed property service that then you actually see kind of more in detail exactly what we're talking about in terms of the property.
Correct. Now, given the data that would be made available, if you were to receive a notice and it says you've got unclaimed property, if you were to go to DOR's website, presumably the way it would work, and certainly the intent, is that you could see from the website yourself what the value of the property is. That it has to be incorporated into the contract is duplicative of what you would see, and that's probably one of the reasons why the rate is so low in terms of people actually utilizing the third parties.
Okay. Senator Parent?
Madam Chair, so to Senator Goodman's point and your chart that demonstrate, very few items of information about the property, how does and you may have said this and I may have missed it, how do the potential service providers find out if it's even worth their while, right? Because I would assume that if they figure out it's the cake pan, they aren't bothering, right? I mean, the amount of time per return, they're going to want to go after the property that's worth a lot, which, I mean,
Instead of that.
I can't really fault them, nor can I fault that would be the ones that are the most meaningful to return to the rightful owner either. I mean, that makes sense to me, obviously, but how do they know what it is to decide, okay, this is one that is worth my time to reach out to this potential customer?
Okay, in Section 8 of the bill, which starts on page 9, that's where it works through the data that would be made available. That would include on line 217 the cash amount. If it's an unliquidated security, you see that in subparagraph 5. So you start to see the value of the property that's there. These are the things that would be made available upon request.
Upon request, it wouldn't be, so in the chart, are those available on the website, kind of to Senator Goodman's point, or are they someone would have to then request it and then get it?
You know, I don't know because it's been some time since I've gone to Florida and Texas's websites. I don't know. And sometimes you have like Georgia does where it says you can only access this if you're looking for your own property. And so, you know, I don't know that if I were to pull up Florida, I would see it there directly. I just don't know, Senator.
Yeah, I think we should find out whether the consumer themselves could see what the value of the property is under the new, scheme is the wrong word, it makes it sound bad, but industry set up here, or whether only they would have to find it, because then it sort of is like the folks that are sort of making their living doing this are incentivized to look, and it would be nice if, since people could do it on their own, if they also could get that same information themselves, because they're not going to be spending a lot of time mining a website the
Right.
way the people who do it for a living would be doing.
Right. I think the consumer, certainly the department could, if this bill were to pass, the department could make it eligible for the consumer or the claimant themselves to see it directly. There's nothing in here that prohibits that. And they could certainly do that either through reg or just even policy in terms of how the database operates.
Well, if they're messing it up right now, we might have to tell them what we want, what we want it to be available.
All right, Senator Merritt.
Yes. My concern, are there any limits on how many solicitations a consumer can get?
I don't know of any. I don't know if there's any limitation right now.
Okay. I guess my concern is I know people get very confused and they might not understand that, number one, there's a fee involved. Number two, because it's not explicitly stated in these solicitations that the consumer can do this themselves. So my concern is if that is not actively stated or they know that, that's my concern. They're getting all of these solicitations and they might not know the real implications of that. And, in the end of it, I could have done it myself. That's my concern.
And I hear you. I don't know today. I guess we all as individuals receive solicitation from a lot of different companies today and about a whole array of issues. And I guess individually we have to take the responsibility. I don't know this company. I need to check them out through the Secretary of State's office, or I need to check them out through the DOR, or whatever issue that is. So I guess at that point, I'd say this bill actually, if these companies are going to work in Georgia, they're going to first verify, DOR is going to verify whether I'm Vance Smith and I can get the information. Then they're going to verify whether company XYZ is actually registered with them, has had the background check, and is a good company. I guess that we kind of have to rely on that. Now, we have to use our own judgment, and then we have to use judgment of the department to tell us that, yes, we've done the background check and this is a viable company, but we first have to call them and find that out. We even have to do that nowadays if this bill weren't passed, Somehow we have to verify who we're dealing with, because there are some unscrupulous people.
Yeah. I'm just concerned that a lot of consumers don't, and they might not know to do that unless it's stated in said solicitation, like, you can work with DOR and you can check these companies via.
No, I hear your concern. I do.
All right, Senator Goodman.
So we passed a bill out of the Ag Committee that Chairman Walker carried, and it was a bill, you've probably seen these solicitations where it costs $50 to update your LLCs with Secretary of State, but these people are sending out these solicitations and charging you $150.
Oh, I got one.
Yes, sir.
And it looks official.
It looks very official.
Yeah, looks very official.
So, I'm supportive of the idea, but I am wondering, I'm curious as to what would be on the notice. Would we say on the notice that, that this is an independent company that's looking to contract to help you with this, but at the same time, that you have the ability as a private citizen to go through the process, to reclaim your property. I'm curious to know what the notice would say, because, all of us folks on this committee, we, or some of us anyway, myself included, are pretty ignorant of this process. And, everyday Georgians getting this stuff in the mail, I do think that we would have a responsibility to make sure that they did understand that they could go through the process themselves if they deemed that appropriate. Thank you, Madam Chair.
I received one of those, Madam Chair, if you don't mind. I received one of those very notices. Fortunately, I registered my own. I'm a LLC. I'm a one-man show, you know. And I saw that, and I said, wow, this does look official, but I just went online and did my own thing, and I just put that in the trash. That's what you hope people do, but some people may not do that. They may rely. They say, well, this must be a company. I can just let them do it, and they're paying 3 times as much, you know. So I hear you on that point.
Okay. Senator Anderson.
Thank you, Madam Chair. By the time I try to research the company, verify if they're legitimate, go through that process, I could have actually gone online and gotten my property by then. Why can't we just require the DOR to do their job?
You make a good point.
Always.
I'll vote for
always,
your bill.
Always. I always make a good point, so.
I promise you.
That's 2 for the day, just now. Within the last hour.
All right. What is the pleasure of the Senator Parent?
Thank you, Madam Chair. So I do a couple things I've been thinking. I mean, so in some ways it's ideal if folks know they have the property and can claim it on their own. Obviously, there appears to be some kind of level of breakdown with that not happening properly, which then leads us to, if you will, like a decision tree of, do you sort of try to get the government to handle this better, the government we control, or do you say, hey, Florida's set up this industry that is succeeding, but when you, and you know, if a goal is to get a lot of property back to the rightful owners, I don't have a strong objection to there being an industry around it. But what I do have concerns about is what are the consumer protections therein, and what are sort of the notice requirements and the things that have been coming up in the most recent line of questioning. And what I would like to propose, Madam Chair, is that we hold on this bill for today. I've actually, and it's, you know, in this limited amount of time, in this rush, I've actually got a couple questions out to some consumer folks. I did, before I came to the state Senate, serve as the executive director of a consumer organization before I came here. And what I would like to do is just sort of run down the answers with you, Representative, and maybe, you know, other senators that raise some concerns about what the notice should say, and just kind of all make sure that we think the way it's set up is going to enable an industry that's going to be fine for the people that work in it, of course, but also safe and fair for the consumers, and that we don't accidentally unleash things that are fraudulent or misleading. And I just hadn't had time to get all the answers on that yet. So that would be my proposal, Madam Chair.
Chairman Burns.
I have no objection to Senator Parent's suggestion. I would just make the observation, was the legislation that you have brought forward, is it crafted after either Florida or California or Texas? Is it similar?
I'd have to let you.
Similar to Florida.
Yeah. Similar to Florida. Do we have any information about complaints from Florida that might shed some light on our concerns?
I think Senator Parent had indicated they had to revisit the statute because there had been some consumer issues in terms of, but I'll let Senator Parent answer.
Well, just very quickly, Chairman Burns, yeah, I do have a printout that I'll share with you from their Florida website that under have you been contacted by a private company, it has a bunch of categories of things it's trying to let consumers know. And so I just want to make sure that in our bill we're got all those I's dotted and T's crossed.
Those are Florida Department of Revenue.
Well, their website, I'd have to look at that. Their website is called fltreasurehunt.gov, but it is out of the Florida Department of Financial Services.
That would get people searching.
So I'll bring you a copy of this, Mr. Chairman.
Like you're going to find that gold at the bottom of the sea. Okay. Thank you, Madam.
Okay. All right, this is what I'm going to suggest. I'm going to suggest that if y'all could work with Senator Goodman and Senator Parent in terms of language around the notice, just in terms of consumer protection, just to make sure that folks know that it's a private company, that they can do it themselves, just some of the basics, and then we can come back and hopefully get it out. Is that agreeable?
Yes, ma'am. Yes, ma'am. We certainly will.
Okay. Thank you for your time. Sorry, it's been a little
No.
a little hotter than usual.
No.
It's
we
extra
appreciate-
special duty today, Representative Smith.
This is special. No, thank you very much, Madam Chairman. We really appreciate it and appreciate all the input. The citizens are the ones we want to protect in the end, and I appreciate y'all's input. and
Yeah,
look
I think
forward-
the thing we've been dealing with the LLC and the registration, I think it kind of just clarifies that we know this can go awry sometimes.
Yes,
So,
ma'am. Thank
thank
very
you.
much. Yes, ma'am.
Thank you.
All right, one more. Representative Walensky.
I wish Belafonte was my attorney.
For a fee, for a fee.
Okay. Thank y'all for having me. This is House Bill 1383 LC 365039. This is a great bill. This is an update by the Georgia Commission of Equal Opportunity. It's an update on the Fair Employment Practices Act of 1978, which is dealing with the administration of the hearings in their commission. And this is just a long-needed cleanup bill that removes a lot of sections that are redundant, not only in this code section, but also with other code sections. And it also makes the process of these administrative hearings and the background that they do easier and better for them, but also better for the people that are involved. And we have here today the Executive Director of the Commission, who is happy to speak as well or answer any questions.
Specifically with respect to line 65, why are we taking the number down from 12 to 8? Do you want to come speak? Yeah.
Good afternoon, Madam Chairman, members
Yeah.
of the committee.
If you'll just say who you are, introduce yourself to us.
Thank you. Good afternoon. I'm Alana Cross, the Executive Director of the Georgia Commission on Equal Opportunity, Office of the Governor. Also present here with me is Jonathan Harris, GCO's Deputy Director, and he'll be available to answer any questions you all may have as well.
Great.
The number is being reduced. With us moving the hearings over to the Office of State Administrative Hearings, there's not a need to have a list of 12 special masters certified and submitted to the Governor's office. So we're just reducing that number to 8 special masters. We will utilize the special master process if we have to have a hearing or complaint is filed or a reasonable cause case against the Office of Administrative Hearings, because they can be a respondent in our cases.
Great. Thank you.
Thank you.
Does anybody have any questions? I think there was so much excitement about unclaimed property.
Thank you. Thank you for your support.
They don't, honey, they verified.
Any questions? No questions? All right. What is the will? What is the will of the committee? Okay. Well, hold on. Senator Parent?
Motion do pass, Madam Chair.
Okay. Senator Parent, motion. Senator Anderson did the second first. All in favor, say aye.
Aye.
All opposed? All right.
Thank you, Chair.
You're out.
Thank you.
Thank
I learned
you.
a lot about unclaimed property.
I think we're all going to go to DOR's website after this. So, all right. Senator Albers. Good carry. Okay. All right. That we will adjourn. Thank you very much.